It's a witch hunt. It's free speech. It's political activity. Won't someone please think of the First Amendment? Special Prosecutor Jack Smith has indicted Donald Trump in Washington, D.C. for conspiracy to subvert the presidential election results, and Trump is predictably not too happy about it. He tweeted out on Truth Social, "If you go after me, I'm coming after you." In response, the DOJ filed a motion for protective order that would prevent Trump from disclosing discovery materials to the public. Now, Trump says this motion was actually a blanket gag order that would prohibit him from exercising his free speech, and a hearing was held on August 11th. Now, in addition to all the motion practice that's happening before trial, Trump and his lawyers say that everything that Trump said in the run-up to January 6th is protected political speech and therefore can't be the basis of criminal charges. Now, Trump has said a lot of things in the context of January 6th. Does he actually have a First Amendment free speech defense? Well, to start with, speech is generally protected under the First Amendment unless it falls within one of the few categories of unprotected speech. Now, we'll get into those categories in a few minutes because when you're talking about Trump, those categories actually come up with quite a bit of frequency. But first, let's talk about why Trump says his words and actions are protected speech. The Supreme Court considers political and ideological speech to be at the core of the First Amendment, including speech concerning, quote, politics, nationalism, religion, or other matters of opinion. Now, Trump says that he's being persecuted for political speech. In the indictment, the prosecutors accused him of communicating with other people in an attempt to overturn the election. And here's how the alleged conspiracies worked. Before the general election, the political parties from each state chose their own potential electoral college electors. After the votes are in, each state prepares certificates of ascertainment that are authenticated with a government signature, and the indictment accuses Trump and his allies of conspiring to prepare fake certificates in 7 states that Trump lost: Arizona, Georgia, Michigan, Nevada, New Mexico, Pennsylvania, and Wisconsin. And Trump's plan depended on Vice President Mike Pence using those certificates to block or delay Congress from recognizing Biden's victory. Now, Trump's lawyer, John Lauro, told CNN that, quote, "This is an attack on free speech and political advocacy, and there's nothing that's more protected under the First Amendment than political speech." Now, I agree with Lauro that Trump generally has a right to lie about the election results forever if he wants to. However, Lauro goes even further than that, saying that Trump had a free speech right to ask Pence and others to take action on his behalf. Lauro often defended Trump by claiming that his extra legal demands were aspirational.
Hold on one second. That was an aspirational ask.
Now, Trump claims that there's no harm in just asking Pence to do something that might hypothetically break the law or at least be against the law. Lauro says that the Biden administration has criminalized the free speech of prior administration and that it is particularly egregious because it's happening while there is a political election happening. To Trump, it looks like the government is trying to stop him from expressing his political opinions. Now, Trump's defenders used the same defense during his second Senate impeachment trial. The House January 6th committee recommended that Trump be charged with violating the seditious conspiracy statute because of the speech he gave to the protesters at the Ellipse. The seditious conspiracy law, 18 U.S.C. 2383 and 2384, make it a crime when someone, quote, incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States. Now, historically, the government has used sedition charges to shut down political dissent, especially during times of war. And Trump is right that we don't want the government to persecute people because of their political speech. But that's why today it's extremely hard to convict someone of inciting violence based on their opinions. We've covered incitement law a bunch of times on this channel. It's very difficult to prove under the Brandenburg test. And although the First Amendment does not protect speech that incites imminent lawless action, it does protect speech that advocates overthrowing the government in abstract terms. Whether the speech really does incite imminent lawless action is a hard nut to crack, which is probably why Special Prosecutor Jack Smith did not charge Trump with seditious conspiracy. Most people think that he probably did this to avoid Trump's First Amendment defense. But Smith still used Trump's words as evidence that he committed other crimes. Now, is he allowed to do that? Well, the government anticipated that Trump would make the case about free speech. So the indictment begins by making the distinction between First Amendment and criminal conduct. Quote, the defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he won. He was also entitled to formally challenge the results of the election through lawful and appropriate means, such as by seeking recounts or audits of the popular vote in states or filing lawsuits, challenging ballots and procedures. Now, this is the Justice Department, so you are allowed to take their statements of fealty to the First Amendment with a grain of salt. But Trump lost the lawsuits that he filed, and the indictment says that Trump tried to overturn the election by illegal means. Quote, shortly after Election Day, the defendant also pursued unlawful means of discounting legitimate votes and subverting the election results. Now, this is the heart of the disagreement between Trump and the Department of Justice. Trump World's argument boils down to the idea that words can't be crimes. And that definitely misunderstands the issue in most of criminal law. As former Trump Attorney General Bill Barr explains.
As the indictment says, they're not attacking his First Amendment right. He can say whatever he wants. He can even lie. He can even tell people that the election was stolen when he knew better. But that does not protect you from entering into a conspiracy. All conspiracies involve speech, and all fraud involves speech.
Now, Barr is saying that there's no First Amendment protection for speech made in service of a crime. So let's talk about that. Now, not all speech is protected by the First Amendment. For example, defamatory statements are not protected. Now, Trump knows this because, for some reason, he's always saying he wants to make it easier for people to sue for defamation. And, he does actually file a fair number of defamation lawsuits. And earlier this year, he lost a defamation case after E. Jean Carroll sued him for claiming that he did not rape her. And on the other side of the coin, Trump has actually won defamation suits against people like Stormy Daniels and was successfully able to file an anti-SLAPP motion against her. Now, false statements may form the basis of other legally cognizable harms such as fraud, false advertising, or perjury. And Trump has been sued for fraud before. In 2016, he settled a lawsuit which alleged that Trump University made false claims about being affiliated with accredited universities, lied about Trump handpicking instructors, and lied about passing on valuable real estate secrets. Now, that kind of commercial speech has fewer First Amendment protections when someone makes false statements. And if the government can prove it has a substantial interest in making sure consumers aren't deceived, it can regulate certain types of commercial speech. And on top of that, things that qualify as speech often constitute what are called legal acts. Yeah, think about it. Speech is often how we accomplish stuff. We tell people what we want and what we want them to do. And generally, the First Amendment doesn't protect speech, quote, used as an integral part of conduct in violation of a valid criminal statute. Now, this is why the government is allowed to prohibit solicitation to commit a crime, or conspiracy to commit a crime, or impersonating a government officer. In each of these crimes, it involves speech, but a prosecutor can use a person's words as evidence that they committed that crime. For example, if a bank robber demands that a bank teller hand over the money, the statements aren't protected speech. Those words form the basis of the crime that's being committed. And under Trump's interpretation of the First Amendment, the bank robber could argue that when he gave the teller a note demanding money, it was merely a suggestion, aspirational, to use Lauro's words. And if we accept Trump's free speech argument, it's hard to see how it would ever be legal for the government to punish perjury, which punishes a person for lying under oath, and other crimes like knowingly making a false statement to law enforcement in violation of 18 U.S.C. 1001 would also be off the books. And unfortunately for Trump, soliciting another individual to commit a crime is not protected by the First Amendment. For example, in United States versus Williams, the Supreme Court considered whether the PROTECT Act abridged First Amendment freedom of speech by outlawing the pandering of material that is believed to be child pornography. Justice Scalia, writing for the majority, concluded that, quote, offers to engage in illegal transactions are categorically excluded from First Amendment protection. The court observed that, quote, to be sure, there remains an important distinction between a proposal to engage in illegal activity and the abstract advocacy of illegality. Scalia concluded that the PROTECT Act was not overbroad because it, quote, does not prohibit advocacy of child pornography, but only offers to provide or requests to obtain it. The opinion goes on to say that, quote, many long-established criminal prosecutions, such as laws against conspiracy, incitement, and solicitation, criminalize speech, commercial or not, that is intended to induce or commence illegal activities. And another case that's on point is the 1915 case of United States versus Mosley that dealt with a conspiracy by 2 Oklahoma County Election Board officials to omit certain legal votes from the official count. The men were charged with conspiracy under 18 U.S.C. 241, which is one of the statutes that Trump allegedly violated. And in that case, the court observed that although 241 was enacted to stop the Ku Klux Klan, quote, the statute dealt at the time with all federal rights of all citizens and protected them all and still continues to do so. The county officials engaged in multiple conspiracies. First, they agreed not to count certain votes. Second, they met in secret without the knowledge of the third member of the Board of Elections for the purpose of carrying out the conspiracy. And third, they committed overt acts towards achieving their goals. The 2 men met and used speech to hatch their plan, but that doesn't mean that their actual conspiracy was protected by the First Amendment. And to be clear, Trump really can't be punished for saying, I think I won and Pence should block the certification. But he can be charged for soliciting another person to commit a crime. So it would follow that if Trump solicited fake electors to submit forged certificates with the goal of stopping the certification, then it's fine to charge him with conspiracy to obstruct an official proceeding under 18 U.S.C. 1512. And the government still has to prove all the elements of the case for each of those charges. Lauro suggests that a person cannot be guilty of conspiracy if their verbal acts solely consist of political speech protected by the Constitution, which has a kernel of truth but is also kind of wrong. He relies on Hammerschmidt versus United States, where the Supreme Court overturned a conviction against Thomas Hammerschmidt and 12 others who had been handing out pamphlets urging men not to register for the Selective Service Act. Now, the act authorized the government to temporarily expand the military through conscription, and the men were convicted of conspiracy to defraud the United States in violation of what is now 18 U.S.C. 371. By the way, there are a lot of First Amendment cases that deal with very, very dubious speech-related acts. But the issue in Hammerschmidt was whether the men used trickery or deceit to encourage people to evade the draft. And the court found that their conduct did not include deceit. Handing out pamphlets was simply, quote, open defiance of the governmental purpose to enforce a law by urging persons subject to it to disobey it, which is not fraud in this sense. The case didn't refer to the First Amendment or discuss whether political speech can contribute to a criminal conspiracy. But the Hammerschmidt case referred to a 1910 case called Hawes versus Henkel, which might be more analogous to Trump's situation. In that case, Moses Hawes and others were charged with a conspiracy to defraud the United States by attempting to bribe a statistician in the Department of Agriculture to give them cotton crop reports before they were officially released to the public with the goal of engaging in market speculation. The statistician was going to, quote, falsify one of these official cotton crop reports, of which fact his associates were to be advised in advance. In Hammerschmidt, the men were handing out political pamphlets urging people to break the law. That was political speech. In Hawes, the men conspired to secretly manipulate cotton crop reports, including by falsifying data to allow the conspirators to engage in market speculation. Now, I'm sure Jack Smith is going to argue that the fact pattern seems closer to Hawes because it involves governmental officials using deceit and trickery to stop the certification of the election of the joint session of Congress on January 6th. Now, to be sure, Trump did engage in political speech, but for the most part, Jack Smith's indictment avoided charging Trump just for making speeches and posting tweets. Instead, it seems like he tried to charge speech acts that urge people, including state and federal officials, to break the law by submitting fraudulent electoral certificates to Congress and NARA. Now, the Georgia indictment, on the other hand, is more explicitly based on Trump's various speech acts, which may present a problem. And there are other cases that Trump might rely on to argue that he had no intent for anyone to commit unlawful acts. For example, in NAACP versus Claiborne Hardware, the Supreme Court ruled that an economic boycott is a form of constitutionally protected expression, even if violence is threatened as a means of achieving a group objective. The case involved an economic boycott by African Americans against white merchants operating in Claiborne County, Mississippi. And the boycott included nonviolent picketing, but there were also acts of threats of violence. And in 1969, white merchants sued the NAACP for damages. And the court held that the nonviolent elements of the protesters' activities were protected by the First Amendment. The NAACP wasn't liable for the consequences of their nonviolent activity. Effectively, the court separated out the nonviolent activity that was protected by the First Amendment and the potentially violent activity that could give rise to damages. And the court ruled that, quote, for liability to be imposed by reason of association alone, it is necessary to establish that the group itself possessed unlawful goals and that the individual held specific intent to further these illegal aims. Persuasion must be, quote, directed to inciting or producing imminent lawless action and likely to incite or produce such action in order for it to be considered a crime. Now, in the aftermath of Claiborne Hardware, lower court decisions drew a line between advocacy and urging illegal action. Speech urging illegal action was unprotected by the First Amendment in some contexts. For example, in Rice versus Paladin, the Fourth Circuit ruled that a publisher of a book, Hitman, a technical manual for independent contractors, could be liable for civilly aiding and abetting a crime after a contract killer used the book to murder 3 people. The court held that the, quote, provision of instructions that aid and abet another in the commission of a criminal offense is not protected by the First Amendment. The First Amendment doesn't bar civil liability for speech that the plaintiff can demonstrate was performed with specific intent. The court drew a distinction between speech that was advocacy and speech that was aiding and abetting others by providing the means to commit the crime. And the court said that the Hitman book was not advocacy. It was an instruction manual without relevant communicative value. But the Hitman case is unusual because Paladin, for reasons that I won't go into, stipulated that it intended the book to be used by criminals and would-be criminals, and that it intended and had knowledge that the book would be used to execute the crime of murder for hire. But for procedural reasons, there was only one issue before the court, and that was whether the First Amendment acted as a complete bar to the plaintiff's claims. And of course, unlike the Paladin publisher, Trump is not going to stipulate that he had specific intent and knowledge that his co-conspirators intended to commit crimes. But the government is alleging exactly that Trump knew his speeches and interviews and phone calls and memos were in service of an objective that was against the law, overturning a legitimate election result. So whereas in Claiborne hardware, the boycotters didn't intend violence and thus were not liable for their First Amendment protected speech, Trump intended, so says the government, for others to break the law on his behalf. And I'm sure Jack Smith will use Trump's speeches to prove that he had that specific intent. And of course, Trump is going on trial for conspiracy, and the First Circuit Court of Appeals decided a case called U.S. versus Spock that involved a letter written by professionals who were opposed to the Vietnam War. These professionals, including famous pediatrician Benjamin Spock, wrote a letter called A Call to Resist Illegitimate Authority. And some of them attended protests which advocated for the burning of draft cards. Spock and 3 others were convicted of criminal conspiracy. The court reversed Spock's conviction largely because he did not have specific intent to further the illegal aspects of the letter. The court observed that, quote, "It is true that he was one of the drafters of the call, but this does not evidence the necessary intent to adhere to its illegal aspects. Nor does his admission to a government agent that he was willing to do anything asked for further opposition to the war. Specific intent is not established by such a generalization. Whatever the reason, the fact is that his speech was limited to condemnation of the war and the draft and lacked any words or content of counseling. The jury could not find prescribed advocacy from the mere fact, which he freely admitted that he hoped the frequent stating of his views might give young men courage to take active steps in draft resistance. This is a natural consequence of vigorous speech." So this looks like a better argument for Trump, that he, like Dr. Spock, repeatedly stated his views publicly in the hopes that it might give courage to people to take some action, but that he lacked knowledge of illegal efforts on his behalf and the intent to see them succeed. Now, Smith's indictment says that Trump's activities included both legal and illegal means of achieving a second term, despite losing the election. But Trump will argue that he never tried to further any illegal activities. What this all boils down to is that the government must prove that Trump had the mens rea, the necessary mental state, to commit the crimes he's accused of. Now, this sounds complicated, but it's actually how all of criminal law works. The exact same act can be perfectly innocent or a crime based on the mental state of the defendant. Now, as you can probably tell, Trump and his co-defendants are going to need a good lawyer. But if you need a great lawyer, my firm, the Eagle Team, can help. If your loved one has suffered from cancer, has suffered an injury or death in the family, or were involved in a car crash, we can represent you or help find you the right attorney. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. The link is below. Now back to the First Amendment. Now, in addition, you might have heard that the special prosecutor moved for a gag order to stop Trump from communicating about the case. Now, that's not really true, but the government did file a motion for a protective order on Friday, August 4th. Now, a motion for a protective order is an extremely routine motion to make, especially in a case that involves sensitive material. So that, in particular, is not unusual. But what happened is that the government filed its motion after Trump went on Truth Social and posted, "If you go after me, I'm coming after you." And in the motion, prosecutors cited the Truth Social post as evidence that a protective order was necessary. The government's theory is that Trump has a history of sharing information that the public shouldn't have. Now, balancing a criminal defendant's right to free speech with the need to keep order in trial and at court, while also balancing the ability of that person to run for president of the United States is, well, tricky. Or as Ken White more colorfully put it, basically it's a nightmare law school exam by a sadistic, drunk law professor. And the government said that the order was necessary to, quote, allow the government to begin producing that discovery, much of which includes sensitive and confidential information. The government respectfully moves the court for entry of the attached proposed protective order governing the disclosure of discovery. Now, mind you, when you have a criminal defendant, that defendant is entitled to see the evidence that's going to be presented against them. This process of turning over information is called discovery. And the point of discovery in the criminal context is to inform the defendant about the evidence that's going to be used against them. And as you might imagine, there's a lot of sensitive information here. Quote, materials containing personally identifying information as identified in Federal Rule of Criminal Procedure 49.1, Rule 6 materials including subpoena returns, witness testimony, and related exhibits presented to the grand jury, materials obtained through sealed search warrants and 2703D orders, sealed orders obtained by the government's filter team related to the case, recordings, transcripts, interview reports, and related exhibits of witness interviews, and sensitive materials obtained from other governmental entities. And the idea is that the protective order, quote, allows the defendant prompt and effective use of discovery materials in connection with his defense, including by showing discovery materials to witnesses who also agree to abide by the order's terms. The idea is that the discovery would be given to Trump, but he wouldn't be allowed to share it with the public. Prosecutors said, quote, such a restriction is particularly important in this case because the defendant has previously issued public statements on social media regarding witnesses, judges, attorneys, and others associated with legal matters pending against him. And not surprisingly, as evidence, the government referenced Trump's Truth Social screed. They said, quote, if the defendant were to begin issuing public posts using details, or for example, grand jury transcripts, obtained in discovery here, it could have a harmful chilling effect on witnesses or adversely affect the fair administration of justice in this case. In response, Trump's lawyer said, quote, the government does not explain how a post on a different topic, which does not include or describe sensitive information, suggests President Trump might disseminate such information in the future. And Trump's lawyer said that the need to protect that information does not require a blanket gag order over all documents produced by the government. And their response brief accused Jack Smith's prosecutors of leaking evidence, stating that the DOJ posed, quote, the greater risk of improper disclosure. Now, Judge Chutkan had a hearing to resolve the parties' inability to agree on the scope of the protective order. And after she issued the protective order, Trump said that he might or might not comply with the judge's order.
Do you plan to comply with the judge's order regarding the latest indictment? We'll have to take a look at the order.
So what were they arguing about? Well, the first big issue was whether all information the government obtained during the investigation should be covered by the protective order, as the prosecution wanted. But the judge was not persuaded that the government proved that all information gathered in the case should fall under the protective order. And the judge ruled that the government can designate certain materials as sensitive, but not all of them. But notably, the judge agreed with the government that every single person interviewed by prosecutors is a potential witness and is therefore sensitive information. The judge suggested that Trump might release evidence about Mike Pence in order to denigrate him as a witness. Quote, the defendant's desire to respond to political opponents has to yield. There are limits. This is a criminal case. The need for this case to proceed in a normal order means there are going to be limits on the defendant's speech. The judge was also concerned that witnesses could be intimidated by, quote, members of the public, also who are not bound by the conditions of the release. Now, Laurel pleaded with the judge to consider that Trump needed to be able to discuss everything listed in paragraph 8 on the debate stage. But Judge Chutkan said that the political campaign would have no bearing on any of her decisions in the case. She chided Laurel for, quote, conflating what your client needs to defend himself and what he wants to do politically. Your client's defense has to happen in the courtroom, not on the internet. To the extent your client wants to make statements on the internet, he has to yield to witness security. Now, the second major issue was whether Trump would be allowed to see all the discovery in the case and what he'd be allowed to do with that material. And here, Judge Chutkan fashioned a compromise. Trump is allowed to review sensitive information without his legal team present in the room, but the team must be present to retrieve the materials as soon as Trump exits the room. If Trump takes notes, his lawyers must review them to assure that he did not write down sensitive personal information. Trump is also not permitted to have an electronic device with him that would allow him to take a picture or photocopy the document. Quote, if the defendant takes notes regarding sensitive materials, defense counsel must inspect those notes to ensure that the defendant has not copied down personally identifying information. Now, this puts a lot of pressure on the lawyers to make sure that their client is complying with the order. Now, with normal clients, this isn't such a big deal, but this is obviously Donald Trump that we're dealing with here. And things are getting especially interesting because in the wake of the protective order, Trump has arguably directed speech at a witness in Georgia saying, quote, I am reading reports that failed former Lieutenant Governor of Georgia, Jeff Duncan, will be testifying before the Fulton County grand jury. He shouldn't, and then goes on even further. Now, that's not great. Now, while some commentators have argued that this constitutes witness tampering, the Georgia witness tampering statute is mainly concerned with threats and bribes and likely doesn't apply here. And Judge Chutkan's protective order prevents Trump and his legal team from disclosing sensitive matters revealed in discovery, but it doesn't really touch on statements like that. Trump's condition of his release do actually bar him from harassing or intimidating witnesses, but that would likely only apply to witnesses in his DC case. So given all the gray areas here, I wouldn't expect any of the judges here to be the first to rush to jail Trump or hold Trump in contempt over his social media posts. But right after the Duncan-related post, he also targeted Judge Chutkan by commenting on her past in-court statements, which is at the very least likely to piss off the judge. Though in fairness, it's not a great statement from the judge. It's a gratuitous reference to Trump, who wasn't on trial in that particular January 6th case. But I'm sure that these are only just the first in a long string of free speech hypotheticals that would drive any student in con law to insane, or a YouTube lawyer, as the case may be. But all this just makes my brain hurt, so I think I'll just sit back and enjoy a delicious meal delivered straight to my door, which I can get with today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat. You can eliminate hours it would take to shop, to meal prep, and to cook, so you can spend your time doing the things that you actually want to do. Factor meals arrive pre-prepared and ready to eat in just 2 minutes. minutes. In the same time that I could even think about going to the grocery store, my Factor meal is already done. Sometimes I just want a good, healthy meal without having to cook, and it's surprisingly affordable. Factor's team of gourmet chefs creates each meal using only ingredients with integrity to help you feel your best all day long, and they really are extremely delicious, like bruschetta shrimp risotto, green goddess chicken, grilled steakhouse filet mignon, ready in just 2 minutes. And their menus are updated weekly with 34 different options. You can choose your favorite meal or let Factor craft your order based on your taste preferences and meal history. So give Factor a try by heading to factor75.com and use the code LegalEagle50 to get 50% off your first Factor box. Or just click on the link that's on screen right now or down in the description and use the code LegalEagle50 to get 50% off your first Factor box. All you have to do is click on the link that's down below. After that, click on this link over here for more Legal Eagle, or I'll see you in court.